Good morning. My name is Molly Sangara. I'm one of the principal associates in our team. And what better way to kick off the new year than to talk about overseas visitors and Brexit? We have Jane and Jill discussing this topic this morning. As always, we have a Q&A function. If there's any questions, do please put them in that chat. Hopefully we'll get a chance to answer any questions that you have, but if not, we will address that in follow-up. At the end of the session, there will also be a pop-up for feedback. We'd be grateful for that to be completed. And also, if there are any topics that you feel would be useful to be covered in the future, please do let us know. We will also confirm the next date of our next seminar following this session in our follow-up communication. But I will now hand over to Jane. Thank you.
Thank you, Molly, and good morning, everybody. I must say, following on from what Molly said there, I do commend you all for signing up to anything that has Brexit in the title. You must all be gluttons for punishment on the middle point of the week. We're going to be really doing what it says on the tin here. I'm not going to be looking at either Brexit itself, you'll be relieved to know, or the entirety of what we might call the healthcare exchange between the UK and the rest of the world. We'd be here all day if I did that. So in exchange for your half hour of dedication this morning, for which we're grateful, I'm going to be looking at the overseas visitors charging regulations and the allied guidance, and having a look at really where they are since the 1st of January this year. So with the post-Brexit changes, what has changed? Why do I need to know what's changed? And what do I need to do? And then Jill will take you through the impact of the new Who Pays guidance and the implications for commissioners of these changes, because obviously I'm really going to be doing the setup. This is very much considered to be a provide topic often, the charging regime, but at the end of the day, who pays all comes back to the commissioner. So we're going to try and tie some of those two areas up for you this morning. We haven't got really much more than or less than about half an hour, so it will be a fairly brisk canter through, but hopefully we will be flagging up the main issues for you. Right, Claire, can I have the next slide, please? So I think before we get started, it might really be helpful to just nail a couple of the definitions that are floating around now in the guidance and in the multiplicity of regulations that we have now. Firstly, exit day. I think we've probably all fallen into the trap of saying at some point last year, when we leave the EU, when we had actually already left. We left at 11 p.m. UK time on the 31st of January last year. Then this was followed most of last year when our attention was slightly distracted by other things going on, I think, and you'll know just as much about that as anybody else. We had what was called the transition period, which ran from the end of January 2020 through to the end of December last year. And that was effectively what you might call a sort of standstill period, sometimes called the implementation period. And the very last day of that was effectively New Year's Eve, IP completion day. And during the transition period, you could almost say that we just kind of very much carried on acting almost as if we were still members of the EU. So the post-transition period, that began after 11 o'clock on the last day of last year. So all change on New Year's Day, and this is where we're really sort of facing up to, oh gosh, yes, we have left and we have to get to grips with the law as it is now. So we're officially post-transition. We don't really have a day for it. It's sort of D-Day in everybody's mind, I think. It's the first day of the rest of our lives, the day from which the regulations will change. And there is sort of scant reference in some of the guidance in connection with the EU settlement scheme that we're now actually in a further period, which is called the withdrawal agreement grace period, and that will now go on until the summer. So the principal regulations that deal with the charging regime are the NHS Charges to Overseas Visitors Regulations 2015. They have been amended and tweaked and twiddled with multiple times since then, largely in 2017, incrementally in 2019, quite a bit last year, obviously, while we were trying to decide whether we were going to have a deal Brexit, a no deal Brexit, and amendments there because of COVID as well. But the amending regulations, if you look at the NHS Charges to Overseas Visitors Regs 2015 on legislation.gov.uk that I know most of you have access to, I had a look at that last night, and that has not been updated because of Brexit. So you will need, if you are looking at the regulations, to look at those that I've put on the bottom of that slide there. So they're the Amendment EU Exit Regulations of 2020. And just be a little bit careful there, because there are some regulations with exactly the same title, Amendment EU Exit Regulations 2019. And they were prepared in the event that we had a no-deal Brexit. So those have now been revoked. So just a little bit of a warning there. I have to say the regulations are now something of a nightmare. I did myself a sort of print off of the amending regulations and then a bit of a Blue Peter cut and paste job so that I could get a fully consolidated version. And they're not terribly user-friendly. I think the original regulations, the principal regulations, which remain the 2015 in themselves, are quite well structured and not too bad to read, but now they are littered with all these references to the withdrawal acts, of which there are two, sundry agreements that remain in place that have been negotiated right up against the deadline between the EEA, EFTA countries, Switzerland. It's not fun. I'm sorry to say that, but it's not fun. And I think it's okay for us to say that it's not fun. This has now become a difficult area. I think there will be clarity over time, but just for the moment, you know, it isn't you. Everybody is struggling with these to get their head around them. But there is a little bright spot on the horizon there, because some rather good guidance has come out, which might just cast a little bit of light on the situation. So can I have the next slide, please, Claire? Okay, so I thought it might be helpful to just have a quick recap on the charging regime before we start. So the NHS is mostly, we're talking about secondary care here when we're talking about the charging regime. We're not talking about primary care, GP registration, anything like that. Jill will come on to that in her talk. But when we talk about charging overseas visitors, we're talking about secondary care. And it's mostly a residence-based system. So it's not a question of whether or not somebody can rock up to the hospital with their British passport. You could have somebody who is a British citizen, who's got a British passport, and they've been living overseas for the last 10 years. They will not be ordinarily resident in the UK, and therefore, you know, they will not pass the test effectively. So you've always got to remember that in this field, the touchstone is what we call ordinary residence. And an overseas visitor, as defined in the regulations, is anybody who is not ordinarily resident in the UK. So the fact you've paid national insurance contributions in the UK in the past, the fact you've got a British passport, the fact you've got British citizenship is not in itself the issue. It all boils down to ordinary residence, and each of those factors may or may not, as we'll come on to see in some of the later slides, feed into ordinary residence. But, you know, it isn't any one thing. You can't just go, oh, somebody gave me a British passport, therefore they're non-chargeable. You've always got to look at whether the person who is presenting in front of you, looking at all of the circumstances, has ordinary residence in the UK. And a person's deemed to be ordinarily resident in the UK when that residence is lawful, it's adopted voluntarily and for settled purposes as part of the regular order of somebody's life for the time being, whether of short or long duration. And there's no time limitation here on how long it takes you to establish ordinary residence. Certainly drawing parallels with social care, they've always said you can establish an ordinary residence within 24 hours because it's largely about intention. You can see from that definition there. It's about voluntariness. It's about adopting something for settled purposes as part of your regular life. In the field of overseas visitors, it does require a little bit more permanence. I think it'd be quite difficult for somebody to establish ordinary residence within 24 hours for this particular context. But that is the concept that we're looking at. So it is ordinary residence, the one you will be familiar with from social care. And the obligation on the provider here is to make and recover charges unless the person falls within a number of categories, which means they will not be charged. So something like somebody who needs a visa to enter the country, they will have paid the immigration health charge as part of that visa application. They will therefore be exempt from charging. Or the service might be exempt. And that, because of the amendments that were made last year, that will include testing, treatment, and vaccination for COVID. Next slide, please, Claire. So I mentioned at the beginning that there is now some rather helpful guidance on ordinary residence, specifically in this context. This is ancillary guidance, so it sits alongside the principal charging for overseas visitors guidance, which extends to 129 pages. This is a much more user-friendly 15-page document. And it looks like it's going to be really useful, particularly in terms of working out whether EEA and Swiss citizens are chargeable or not. And that's really the thrust of where we're looking today, because to a large extent, people formerly, when we looked at Europeans in the context of overseas visitors and charging, they were the easy people to deal with. They were mostly going to be exempt under one of the provisions in the regulations: free movement, reciprocal arrangements, social security arrangements. We had lots of these. And you could almost sort of go, oh yeah, quick look at the regulations and assure yourself that they weren't going to be chargeable. Now we have a whole range of people who are from EU states, EEA states, so that's your Iceland, Norway, Liechtenstein, and Switzerland, who I always think you have to be a little bit careful with Switzerland. Sometimes the Swiss are in, sometimes the Swiss are out, but here they all seem to be grouped in, and they're just called EEA and Swiss citizens. But this is way more accessible, this guidance, I'm finding, than the actual amendments to the regulations. It's very unlike me to say to people, go straight to the guidance, ignore the regulations. Lawyers love regulations, and that is where the law sits, and the guidance can only ever be an interpretation. But I have to say, this is really looking very helpful. It's only 15 pages, and it has some quite useful categories listed therein for you. Next slide, please, Claire. So essentially, persons who are subject to immigration control, and that's people who need leave to either enter or to remain in the country. And what the legislation says basically is that anything short of indefinite leave to enter or remain, and you are not ordinarily resident. However, there's always going to be a however. You'll probably have heard about the EU settlement scheme. And there are various sort of embellishments now on this rule about indefinite leave to enter and remain, which derive from the post-Brexit situation. So the ordinary residence requirement will now be satisfied by EEA and Swiss citizens and their family members who are living and working in the UK on or before 31st of December last year, if they have applied for and been granted what is called settled status under the EU settlement scheme. So broadly speaking, what we have now is people who were living and working in the UK before Brexit. They were very much encouraged, if they wanted to remain, to apply through the EU settlement scheme to get settled status. And there are various strands, without going into too much about the EU settlement scheme itself, which is probably one more for my immigration colleagues. There are various strands of obtaining settled status, depending on how long you've been living and working in the UK prior to Brexit. So some people might still be working their way towards settled status because they haven't been here long enough. but the intention is there, the duration is going to be there. It's all part of an ongoing process. So even people on that final bullet point on that slide, even people who haven't yet acquired settled status, but have been granted limited leave to enter or remain under the settlement scheme, or they were lawfully resident here during last year and they're going to continue to be so during what I referred to as the withdrawal agreement grace period. So that's between the 1st of January this year and the summer. They are now, or can be considered as being ordinarily resident, because they will have evinced a clear intention to adopt the UK as their home for the time being. They will be settled here, they will be working here, they will be paying national insurance contributions here. So even though they are still a little bit short of what's called settled status, they're pre-settled or they're within this grace period, they can still be considered to be ordinarily resident. Next slide, please, Claire. So that's just one example. I think you've leapt over a slide there, Claire. Oh, no, I'm lying, sorry. I put another slide in, that's why. So those outside the EU settlement scheme, there's various ways in which they can still obtain healthcare without charge. So the first one I've got there is citizens of the EU, the EEA countries and Switzerland who moved to the UK from the beginning of this year for a period of more than 6 months. They will now have to pay the immigration health surcharge as part of a visa application. So then, as Jill will confirm, they will fall within one of the exemptions. Anybody who's paid the immigration health surcharge can receive secondary care free of charge. We've also come to a particular agreement with Norway so that any visitor to the UK from Norway will be able to access medically necessary care in the UK on presentation of a Norwegian passport. And I think that one's also reciprocal if anybody here is planning a holiday in Norway when we can finally get away. Visitors from Iceland, Liechtenstein and Switzerland, now if they fall ill or have an emergency during a temporary stay in England, so they've come over on holiday, this is something that's going to be way shorter than the 6 months, they may have to pay. And any treatment that has to be paid for will be charged at 150% of the national tariff. And that is the same for all overseas visitors now. If you are chargeable, whether you are a European citizen or someone from a non-European country, that is the standard rate, 150% of tariff. But anybody who doesn't fall within any of those exceptions and is not receiving an exempt service is potentially chargeable. Next slide, please, Claire. So the other categories that have been covered very thoroughly in the guidance deal, and I'm not going to go through all of these now, but I've listed them on the slide so that you can just see what the 15 pages deals with. British citizens and their family members of settled persons, you've got non-EEA family members of British citizens, family members of the people of Northern Ireland. People are always very surprised by that one being there, Northern Ireland being part of the UK, but of course we've now got a Northern Ireland protocol, so that's just shading and feeding into the charging regime. The separate sections on EEA and Swiss citizens, on students, on people who are still living in the UK at the end of the transition period, students whose courses straddle the transition period or who start a course after the end of the transition period. And it also deals just very briefly with Commonwealth citizens, humanitarian cases and refugees, and what they call derivative rights. Next slide, please, Claire. So there's still other modes of access to healthcare that are available, which won't be charged for. So people who are coming on short-term visits from the EU, they can continue to access medically necessary healthcare using their equivalent of what we know as an EHIC card. And they can also secure planned healthcare that's available through the S2 funding route. So that's when you actually go through an application process with your home state and say, I need to go to another country, in this case the UK, to receive planned medical treatment because, for example, I can't access it within an appropriate amount of time in my home country. So the S2 system, that works reciprocally for people coming here from Europe, and basically the NHS recovers its money direct from the government of the country of which the patient is a citizen. Somebody who's ordinarily resident in Europe or Switzerland who gets a state pension paid by the UK government and holds what we call an S1 healthcare certificate. So in other words, they've worked and lived in the UK before, they've paid national insurance in the past, and they're eligible for an S1. They will not be charged for healthcare, even though they're now living in Europe. And of course, there's always, I think often, rather than wade through all this and try and work out whether somebody's chargeable or not, because you have categories of people who are exempt and you have categories of services that are exempt, it's much quicker to look at the service first. Look at the service and say, is this a chargeable service? There is no point waxing lyrical about withdrawal agreements and EEA citizens and EFTA agreements and goodness knows what else, if actually what somebody needs is a service that we're not going to charge for anyway. There's a whole list of these in the guidance and in the regulations. So what we might call public health transmissible diseases. So measles, rubella, TB, MERS, SARS, and COVID, of course, was added last year. So all those things that, from a public health aspect, we want to encourage people to come up for treatment. We don't want people going, oh my goodness, I'm not going to be able to prove that I have ordinary residence in the UK, they're not going to treat me. We don't want that. This is a public health emergency type of situation, and we want people to come forward for treatment. So we just aren't going to charge for that. Contraceptive treatment, any treatment that is for the effect of torture, FGM, sexual violence or domestic violence is not charged for. And some types of palliative care, so that will pick up those of you who deal with CHC. You need to just look at whether that's going to be provided by a registered charity or a community enterprise, and that will not be a chargeable service. Next slide, please, Claire. So I think we've been inundated with wellbeing advice during lockdown, and they've said throughout that we should be kind to ourselves, not expect too much. The whole landscape has changed. And I think this is very much an analogy that I can draw with what's happened with Brexit and the charging regime. If Brexit isn't your daily bread and butter, and I can put my hand up here and say it's not mine, I have a superb immigration team here that I work very closely with on this sort of thing. But, you're specialists in healthcare. You're not, as far as I'm aware, immigration law specialists. If you are, I'll take your phone number later. But, this is new. This is horrible. European visitors who needed healthcare, they were a nice, easy category before. This is now turbulent waters. When we work our way through it, and in a couple of years' time, 5 years' time, we may say, oh, actually, now the sort of lie of the land is a little bit clearer and it's less foggy and less murky. Things have settled and it's a little bit clearer. But at the moment, there's just too much, I think, whirling around. The waters are fairly sort of turbid. Knowing whether somebody is or is not chargeable can be extremely difficult. So it's difficult, and it's okay for us to admit it's difficult. But the new ordinary residence guidance is good. Use it. It's only 15 pages, there's a lot of stuff in there, and it sits alongside the principal guidance. And when you know that you don't know something, that's the time to seek advice. We're here, we want to be useful to you. If we can help, pick up the phone. So that's a very, very quick trot through, a sort of set up to Jill, who's going to now lead on how this looks to you from the commissioning side. But I hope that was helpful as a quick reminder. So now over to Jill.
Thanks, Jane. I'm going to canter through the relevant points of who pays. So if we could just move on to the next slide, please, Claire, that'd be great. Thank you. So if you have a visitor from overseas who is not a chargeable visitor, so who falls into the having paid the surcharge or is regarded as being ordinarily resident, what do you do with them? And this is where sometimes the regulations and the rules can get quite murky, because you are picking up a patient who effectively, as commissioners, you may know absolutely nothing about, and who may have been in hospital for some considerable time and who may be looking to be difficult, complex and or expensive. So quick recap on responsible commissioner rules now. Usually the responsible commissioner is the CCG, who is responsible for the GP practice where the individual is registered. In some of these cases, you may find that you are dealing with patients who have temporarily registered. That's good enough. Or you may have someone who has registered permanently because they are lawfully in the country, they've moved in with family, and so they have gone and got themselves put on a list. So the reasons for them being on the list, not relevant. What matters is whether or not they are on the list. If they are on the list, they are your responsibility if you are the commissioner for that particular GP practice. If then you are looking at someone who isn't registered with a GP, and a large number of these individuals, generally speaking, tend not to be, then you look at usual residence, because that is the requirement in relation to determining responsible commissioner and who pays. Slightly different from ordinary residence, and we have talked about the difference between ordinary residence and usual residence before ad nauseum, but effectively for these purposes, they are broadly the same thing. Is somebody for the time being exhibiting a clear, voluntary and settled intention to live in a particular place? If they are probably yours, and there are some exceptions to that which are set out in Who Pays sections D12 to 19. I've said it before and I'll say it again, Who Pays is good guidance, it's clear, it's straightforward, largely. Run with it and look at it. Don't forget that transitional provisions run from the 1st of September 2020. So if you're being asked to pick up, for example, discharge planning or CHC assessments for somebody who has been in hospital from prior to that date, and you're being contacted now because of some of the Brexit complications, be really careful with your dates, be really clear about what you are being asked to do and why, and then work through the guidance in Who Pays. And there is some useful guidance in Who Pays specifically in relation to overseas visitors, which are tucked away after you've gone through all of the general principles in sections 11.9 to 11.12. So if we could have a quick look at that, please, Claire, next slide. So it's also important to identify the responsible commissioner, even where an individual is liable to pay charges. That shouldn't come back to you as commissioners in terms of financial contribution unless there is an issue with the charges recovery, because the government has decided that there should be risk sharing arrangements put in place between providers and commissioners so that the providers don't take all of the hit in relation to providing services that they don't then get paid for. So where a visitor is exempt from charges, effectively the following process is as set out in Who Pays. You look at GP registration. If they're not GP registered, you look at whether they're resident inside the UK or outside the UK. If they are resident outside the UK, then I'm afraid commissioners where the provider is located are going to pick up, because you're then in a situation where if you work through Who Pays, you've got no GP registration, they are ordinarily resident outside the UK, and therefore they're treated as not being usually resident within the UK. And so as you work through your standard process in Who Pays, it's the CCG for the provider organisation that picks that up effectively as the commissioner of last resort. if you've got a commissioner who is located in the UK who does pick up under those provisions in Who Pays and the guidance in Who Pays, then that gets picked up by them, as I've just explained. If you've got someone who's not GP registered or resident, then these are the classes of individuals who you are likely to pick up with, set out on the next slide. So these are the groups of patients that are listed. Can I have the next slide, please, Claire? There we go. So these are the classes of individuals where the provider location CCG is likely to pick up. And having a look at the time, I don't really have time to go through those, but they're there on the slides. And there is also some guidance and a link set out at the bottom of that slide in terms of those countries which have bilateral healthcare arrangements, and those will be updated as additional arrangements are put in place. The next slide sets out the individuals where somebody is GP registered or treated as being usually resident. So if you could just move on to that, please, Claire. There we go. There is a big list here of classes of individuals who are likely to be caught by the CCG, which is responsible for effectively what will be the address at which the individual is living if they're not registered with GP. And particularly relevant here, as far as I can see, are those employed by UK employers or those self-employed, and students on a course of at least 6 months duration, because students are usually regarded as being subject to immigration control, but because they are here for 6 months or more, they're actually treated as being usually resident in the UK for the duration of their course. So be a little bit careful if you are dealing with students, because they can sometimes be a little bit tricky. As Jane has mentioned, the next slide deals with issues relating to health surcharge, and the bottom line there is that once an individual has paid the health surcharge, they are entitled to non-chargeable, in this context, services from the NHS, and that means that they will fall to be identified as commissioner responsibilities. So you will be picking up responsibility for individuals who have paid the health surcharge in relation to the services that they are receiving from secondary care. So that is quite a potentially big class of individuals now that we are in the post-Brexit period, and individuals who are coming over here for any significant length of time will be paying those fees, and therefore they will be treated as being usually resident here and therefore exempt from charges, and therefore somebody will come and talk to you potentially as responsible commissioner for any ongoing care that they need. Just a reminder that if somebody changes address or GP whilst in hospital, you need to go to 13.6 and 13.7 of Who Pays. Sorry, that's the next slide, Claire. I'm getting ahead of myself slightly. And that you need to look at the responsibility for the whole of the period of inpatient care. So there may well be a little bit of detective work that you as commissioners may need to do to track individuals and see where the address at the point of admission was, because we may well be talking about a continuous period of care. So after that whistle-stop tour of how that clicks in with commissioning, the final slide, Claire, is the takeaways. And the first half of this is Jane's reminders really. Keep the principal and ancillary guidance that you've got to hand. It's useful and use it. Be kind to yourself. And we're back to Donald Rumsfeld and the known unknowns. If you know that you don't know something, ask somebody who does, or somebody who might be able to help you find someone who does. In terms of the commissioning, make sure that you have checked the status of the patient that you are talking about and that you know whether they have paid the surcharge or not. They should have, or you should be able to obtain the relevant copy documentation to confirm what is going on. Work backwards or forwards depending on what you're looking at. Start with the services, look at whether or not somebody is chargeable or not, and also bear in mind that for these individuals, as with all individuals when we're looking at the new Who Pays guidance, you may have a different funding CCG to the responsible commissioning CCG, depending on what is going on in the background. The final slide is a thank you. That has been a lot of information to take in the last 37 minutes. I'm sorry that we've gone slightly over time. I'm afraid we're not going to have time to pick up any questions, but if there is follow-up, we will deal with that as best we can. Obviously, the caveat for the majority of the commissioning Who Pays seminars that we did last year apply here. If it's really detailed advice that you're looking for, we're not going to be able to cover it here because it is so fact specific. Everything depends on the individual circumstances, but we'll do the best we can to point you in the right direction. Thank you very much for making it this far, and stay safe, and we hope to see you at the next seminar.